certainly.
And so to get a mixture, it would require the contributions of different individuals, would it not, sir?
The mixture would require the contributions of more than one person, that's right.
And by that you mean by different individuals, is that correct, sir?
Yes, yes, I do.
Okay, so now what I'd like you to do is to look at the individual genotype frequencies of those individuals who could contribute to this mixture.
I don't think I can do that from this chart. I don't see the frequencies of the pairs of individuals who could have contributed.
Sir, I'm asking you to calculate. I understand how you disagree with this approach. I'm simply asking you to calculate the individual frequencies. And my first question, sir, is, according to the chart that you have, are there frequencies listed in the cell mark table for the genotype frequency for the 1.1, 1.1 genotype?
Yes, there are.
And what frequency do they give?
Well, Cellmark lists the 1.9%.
Okay, and do they also list a frequency for their African American database?
Oh, yes. Yes, that's 2.3%.
And do they also list one for their Hispanic database?
And that is 16%.
And then do they also have the genotype frequencies for the second genotype, 1.1, 1.2?
Yes, they do.
And just to save some time, are the numbers that I have on that table consistent with the numbers that you have on the Cellmark table?
Referring to 1202 and 1201 respectively.
The numbers on the shorter table are an extraction of the numbers on the bigger table, yes.
There's nothing inaccurate in my writing down or recording the numbers on Defendant's Exhibit 1202, is that correct?
I don't see any. I'm sure they're correct.
Okay. And can you think of any other genotypes of individuals who could contribute to the mixture on the steering wheel other than the 6 genotypes that I've listed on the table?
Well, the contributors to the mixture, of course, are a mixture of people. There is no single genotype not listed here that did not contribute. Did I get that right? I think the answer is yes.
Okay. Yes, there are no others other than what's listed here. Is that correct?
Yes, sir.
Okay. And, sir, if you now sum up the frequencies of individual frequencies who could contribute to this mixture, first using the Caucasian database that Cellmark relies upon, is the number 45.4% an accurate number of the summation of those frequencies?
I'm not going to check that. I'll assume that it's accurate.
Okay. And is the number 59.2% reflect the sum of the frequencies of individuals who could contribute to this mixture in Cellmark's African American database or table that they rely on?
Yes, those numbers are probably sum to 59%.
And is the frequency 48.8% of the population the number that one would arrive at relying on Cellmark's Hispanic database?
That's true.
Now, sir, what I'd like you to do is go back to the question that I initially posed and then walked away from, which is what percentage of the population could contribute that number 4 allele that we know that neither Mr. Simpson could contribute nor Nicole Simpson Brown could contribute, and we know Ron Goldman is also excluded. And I want to ask you just about that one now. Get another copy. Oh, no. You're on. This next slide be marked as Defendant's 1203, and I'll offer you a miniature copy of it, Dr. Weir, to assist you.
Thank you. Thank you.
Now, Dr. Weir, again, what I want you to do is to rely on the Cellmark tables. And just looking at the possible genotypes that could contribute the number 4 allele, is this slide correct in saying that the 3 possible genotypes are the 1.14, the 1.1, I'm sorry, let me start all over again. Would you agree, sir, with this table that the genotypes of individuals who could contribute the 4 allele to this mixture on the steering wheel would be somebody who has either a 1.14 genotype, somebody who has a 1.24 genotype, or somebody who has a 4,4 genotype?
Yes, if the person was a contributor to the mixture, they must, and they gave a 4, they must have a 4, and they must not have anything other than we see in the mixture, so that's correct.
Okay. And again, looking and relying on the cell mark tables in front of you, sir, are the frequencies that I have here for somebody who has a 1.14 genotype correct for the 3 different databases, namely 9.5%, 7.7%, and 9.9% of the population?
Well, they're in a different order. They're in a different order from what's on the chart, but at least I think they're correct. Yes, I think they are.
Okay. And are the frequencies from the 3 different cell mark databases for somebody who has the 1.2,4 genotype correct in the slide on the board?
The 3 numbers are there in a different order, yes.
All right. And finally, the frequencies for somebody who has a 4,4 genotype. Are the 3 numbers up there the correct population frequencies for that particular genotype in the 3 different cell mark databases?
Yes.
Now, like the next slide, which will be 1204. Dr. Weir, you already have that before you.
I can't read that small. I'll go from the screen.
Okay, fine. And sir, if you simply sum the frequencies for the various genotypes, as is shown in this slide, according to Cellmark's database, would you agree, sir, that 40% of the approximately 40% of the African American population, according to Cellmark's database, of course, has a genotype which is consistent with being a part of this mixture?
I think that's right. 40% is the sum of all the individual people who have one of their alleles of type 4.
And sir, would you agree that, again, using the same Cellmark tables, that approximately 31% of the Caucasian population, based, of course, on their Caucasian database, also could not be excluded as a possible contributor to this mixture?
That's right.
And finally, given Cellmark's Hispanic database, that approximately 38.4% of the population could not be excluded as being a contributor of that 4 allele.
Well, I do have to accompany my response by saying that that's correct, but I don't think it has any bearing on the interpretation of a mixture.
I appreciate that. Now, Dr. Weir, during your direct examination, you defended or supported, shall we say, Cellmark's and DOJ's use of the product rule to generate the frequencies in this case. Is that correct?
That's right, yes.
Would you agree, sir, that within the fields of statistics and population genetics, there has been controversy regarding the appropriateness of the product rule as it is used, for instance, by Dr. Cotton and Mr. Sims in this case?
You'll have to be more specific. I'm not sure exactly what you're meaning. A lot of people said a lot of different things. You started talking about independence and then you started talking about controversy, so I need to understand what you're asking me.
Well, has there been controversy about the methodologies used by laboratories such as Cellmark and DOJ to calculate the rareness of a particular DNA profile over multiple loci?
Well, I'm not sure that I can answer that very clearly. There are published ways validating the procedures used. Some people have made statements critical, but the various statements are all over the board, so we need to be focused on what specific aspect you're talking about. We can discuss that in some detail.
Well, let me ask you this, Dr. Weir. Did you testify yesterday morning at a hearing in this courtroom prior to your testifying before the jury?
Yes, I did.
And when you testified at that hearing, didn't you say that you wrote letters to different publications because you believed that the way those publications covered the debate on these issues was one-sided? Did you say that yesterday?
Yes, I said that.
Okay. So when you said there was a debate, you meant that there was a debate within the scientific community, did you not?
Not quite. There was a debate, and I would classify that debate as being almost in the popular press. That wasn't a scientific literature debate. So I want to be clear about that. I have written letters to the editors of journals that have essentially carried news stories about this forensic uses of DNA. That's different from the scientific literature.
But you were referring to a debate when you gave that testimony yesterday.
The debate was the debate was not in the scientific literature.
Well, Dr. Weir, you said that you are familiar with the National Academy of Science NRC report, correct?
Yes, I am.
And this report was authored by a committee of distinguished scientists and forensic scientists and others. Is that correct, sir?
That's certainly correct.
And you would agree the National Academy of Science, which is responsible for this undertaking, is an extremely prestigious scientific organization in this country. Is that
Yes.
a fair statement?
Yes, it's a very prestigious organization.
Would it perhaps be the most prestigious organization in this country?
I think that's a fair statement.
And this report represents the National Academy of Sciences National Research Council's effort to address the various issues involved in DNA technology and forensic science. Is that correct?
Yes, it's a report set up by that body and actually conducted by a committee of members outside the body, but it's under their aegis. Yes.
Well, the chairman of this committee was Dr. Victor McCusick. Is that correct?
Yes, it was.
And you're familiar with Dr. McCusick's reputation, are you not?
Yes, I am.
He's an extremely distinguished scientist, is he not?
Yes, he is.
And he is an extremely highly regarded geneticist, is he not?
Yes.
In fact, Dr. McCusick, who's the chairman of this committee that authored this book, is a member of the National Academy of Science, isn't he?
Yes, he is.
By the way, are you a member of the National Academy, sir?
No, I'm not.
Now, aside from Dr. McCusick, Dr. Weir, there were other very highly regarded geneticists on this committee. Is that correct?
Yes, certainly.
And there are also highly regarded forensic scientists on this committee. Is that correct?
Well, I assume so. I'm not familiar with that field so much, but I assume they're reputable and highly regarded.
Well, you've attended some of the meetings within the forensic community over the last few years, haven't you? And given talks?
Yes.
Given-
all I'm saying is I'm not as familiar with those people, but I understand that they're very good.
Huh. Well, do you know who Paul Ferrara is, for instance?
Yes, I have met him.
And do you know him as the head of the Virginia Division of Forensic Science?
Yes, I do.
And based on what you know of him and what you've heard in the community, does he have a very distinguished reputation
Yes, certainly.
in the forensic science community?
Yes, certainly.
And he also sat on this NRC committee, did he not?
Yes.
And Dr. Haig Kazazian, do you know who he is, sir?
Yes, I do.
And is Dr. Haig Kazazian a very distinguished geneticist in this country?
Oh, certainly.
And he too sat on this committee that authored this report, correct?
Yes.
And then we come to Dr. Mary Claire King. She was another member of the committee that authored this report, and she too a very distinguished geneticist.
Yes.
And in fact, in the document which you've read, they describe Dr. King's expertise is in the area of genetics as well as population genetics. Are you aware of that?
Yes, I believe that's what it states, yes. And it's a true statement.
And also included in the same group was Dr. Eric Lander, is that correct?
Yes, Dr. Lander and Dr. McCusick and I have a bond in common, of course, because we were on the subsequent NRC committee to examine some of these issues.
Well, when you say the subsequent NRC committee,
The subsequent
you're not on the committee that's asked to draft another report. You were on a committee that considered the propriety of setting up a second committee, isn't that correct?
we were on the committee that unanimously recommended a new report be issued to clarify some of the problems with the present report, yes.
And was Elizabeth Thompson also on that committee?
Yes, she was.
And you're aware that she disagrees with you on some of these issues, aren't you?
Oh, no,
Overruled.
no, I'm certainly not.
How about, was there a Dr. Zabel who was also on that committee?
I don't remember Dr. Zabel being there, but I've seen his name, so obviously he was there, yes.
And are you aware of the fact that Dr. Zabel also disagrees with your positions on some of these issues of the correct statistical approach to interpreting DNA evidence?
Sustained.
And is Dr. Lander a very distinguished member of the scientific community?
Dr. Lander and I think, are in agreement on the need for a new committee. He is very
Excuse me,
distinguished.
sir.
Yes.
Your Honor, I would ask you to ask the witness to be responsive.
Answer the question, Doctor.
Is he a distinguished member of the scientific community?
Certainly, Dr. Lander is a very good scientist.
And Dr. Henry Lee was also on that committee. Are you aware of Dr. Henry Lee's reputation in the forensic science community?
Only vaguely. I've seen his name in the newspapers.
And Professor Dr. Richard Lempert was on that committee as well, correct?
Yes, I know Dr. Lempert now quite well.
And he's an expert in the field of statistical inferences in evidence, is he not?
Yes, he and I share our common belief in the correct way to interpret these evidence.
We'll get to that a little bit later, Dr. Weir. And Dr. George Sensabar was also on this committee, correct?
Yes,
And he's also a very highly regarded member of the forensic science community, is that correct?
yes.
And Dr. Thomas Marr is also a scientist who sat on this committee as well, right?
Yes, I don't know Dr. Mara. I know his name's listed, but I don't know him.
Well, as not only do you know his name, but you know his reputation as a leading geneticist.
I must confess I don't in any detail.
Right. Now, this book, authored by the NRC committee and authored by the individuals who I just listed to you, states, does it not, that there is a substantial
Objection calls for hearsay, Your Honor.
Sustained.
Sir, in your report, do you cite the NRC report?
I list it, but my report does not depend in any way on the NRC report.
Have you considered the NRC report in reaching your positions on the appropriateness of using certain statistical methods for interpreting DNA evidence?
Certainly not.
You haven't considered it?
Certainly not.
Have you in fact written papers and articles or letters to people criticizing positions taken in the NRC report?
Yes, I have.
Now, I'm not asking you, sir, at this point about the correctness of what the NRC did. I'm simply asking you whether or not the NRC recognized a controversy in the...
Objection, hearsay, Your Honor.
Overruled. Controversy in what particular area, counsel?
Yes, Your Honor. Simply asking you, sir, not whether you agree or disagree with the NRC's position, but did the NRC report acknowledge that there is a substantial controversy has arisen concerning the methods for estimating the population frequencies of specific DNA typing patterns?
Same objection, Your Honor.
Overruled.
That misleading statement is in the report.
But it is in the report,
That misleading statement is in the report.
and it is the position expressed in writing by the authors who we just described.
Well, I'm not sure it's the opinion of all the authors on that report.
But did I quote the report accurately?
I'm sure you did.
And I believe you said that you made formal submissions to the NRC committee. Is that right? That authored this report.
Yes, you and I were in the room at the same time when I spoke to the committee.
And At that point in time, you didn't say to yourself, Dr. Weir, I'm not going to make a presentation of them because these people don't know what they're talking about, did you?
Oh, no, I was very excited about this committee. I thought it was a group of fine scientists and that we might get a document to guide us in the future. I was very pleased to be there.
But you didn't like the final product that was turned out, did you?
No, I don't.
And in fact, the NRC chose to reject your opinion as to the appropriateness of the then current methods for estimating those population frequencies, didn't they?
Objection calls for hearsay.
Sustained.
Well, Dr. Weir, did you feel resentment about the fact that the NRC report reached a different conclusion than the one you would have wanted?
Same objection.
Overruled.
Well, I'm not sure there's no single conclusion in the document. Could you tell me which one you're referring to?
Fine. This conclusion, quote, although mindful of the controversy, the committee has chosen to assume for the sake of discussion
Objection
that,
hearsay, Your Honor.
Sustained. Let me see council sidebar. What was this?
I would like to pick that up later.
Nope. That's final. Proceed.
Dr. Weir, did you resent the fact that the National Academy of Science report did not take your advice and recommendations as how to calculate population frequencies?
That's too broad. I'm sorry. If we're talking, you have to tell me exactly what we're talking about because there are many aspects to that question.
Okay. Dr. Weir, did you resent the fact that the National Research Council came up with an approach to calculating population frequencies which gives considerable weight to the possible presence of population substructure?
Overruled. He's already testified to taking substructure into consideration in his testimony.
I agree with the need to incorporate substructure.
But did you agree with the manner that the NRC chose to incorporate substructure?
What are you talking about specifically?
Do you agree, I'm sorry, do you resent the fact that they came up with a ceiling principle approach to handling the issue of substructure?
Objection.
Overruled.
The ceiling.
Go ahead.
The ceiling approach is not the appropriate way to account for population substructure.
And in your testimony and in your discussions with the NRC committee, did you take a position opposed to using the ceiling approach?
No. When I had discussions with the NRC committee, it was before the ceiling approach was formulated.
Okay, well, did you take a position that was inconsistent with utilizing the ceiling principle?
It never arose. If you recall, my testimony before the NRC committee had to deal with the use of measures of genetic distance, and I touched upon my independence testing. The concept or the issue of substructuring did not arise at that point, and I didn't address it.
Okay, so do you resent the fact that the NRC committee chose to adopt the ceiling approach to handling population frequencies?
Objection vague also.
Overruled.
Vague.
I don't resent anything. I think the ceiling principle is the wrong way to do something. That's not resentment.
Now, I believe you said a moment ago you referred to a second NRC committee. Is that right?
Yes, I did.
And is it true, sir, that once the NRC report was published, it inspired additional controversy in the scientific community?
I don't like the word additional. The report itself generated controversy.
Well, sir, the report itself says that it was created and written because of the controversy surrounding these issues, didn't it?
I've already said that I don't believe that the report was accurate in describing a controversy. However, the book itself certainly created a controversy.
And in fact, there was sufficient controversy, I think, as you pointed out a moment ago, that a determination was made to establish a second NRC committee to reinvestigate some of these issues. Is that correct?
Yes, the NRC committee convened a panel of which I was a member, along with members of that original committee, and we recommended that they issue a new report.
And also, I guess you said that some of those other scientists who were not part of the original committee that I just mentioned, namely Dr. Thompson and Dr. Zabel, were also present at that committee meeting.
Yes, there were several others, yes.
Now, when they came time, though, to select the members for the second committee, you were not included as one of those people. Is that correct, sir?
I was excluded by the ground rules of the membership of the committee.
And do those ground rules include the fact that you were perceived as a partisan on this issue?
Apparently. A partisan, yes. I had spoken out sufficiently to be perceived as having strong opinions.
And the second committee has not yet published its findings. Is that correct?
That's correct, yes.
Isn't it a fact, sir, that as recently as last November, just to give a sense of the continuing nature of this controversy, Dr. Weir, isn't it a fact that as recently as last November, 25 scientists in the fields of statistics and population genetics signed a letter asserting that the country...
Sustained.
Sir, did you receive a copy of a letter?
Sustained. We're not going into that. We broached this once before. We're not going into that letter.
You're on the sidebar, Your Honor?
Nope.
So you said earlier on direct examination that Dr. Elizabeth Thompson is somebody whose work you've actually relied upon in doing some of the tests that you've done on forensic data. Is that correct?
That's correct. I think very highly of her work, and I was pleased to be able to use it.
And you regard Elizabeth Thompson as a extremely well-regarded member of the scientific communities involving population genetics and statistics?
Yes, I do.
And are you aware that Dr. Thompson takes the position that there is,
Objection calls for hearsay.
Sustain.
have you ever read anything signed by Dr. Thompson describing her agreements or disagreements with your positions concerning use of the product rule?
Objection calls for hearsay.
Overruled.
No.
Have you ever seen a letter authored by Dr. Elizabeth Thompson describing the extent of the controversy on this issue?
Objection calls for hearsay, also assumes facts not in evidence.
Overruled. Have you ever seen such a letter?
I don't think so. I've seen, and I'm trying to, you will need to show me what document you're talking about, of course.
1203?
Four.
4?
1204. 1204. 1205. 1205.
An objection based on what the court has already stated.
No, the question was, is he aware of any such? He can be shown the item and asked if he recognizes it.
Yes, I have seen this letter before.
And have you not only seen the letter, but you've also seen the list of signatories, correct?
Wait a minute. Over at the sidebar. Give me that.
Dr. Weir? Do you know who Dr. Marcus Feldman is?
Yes.
Objection relevant, Your Honor.
Sustained.
Dr. Weir, when other well-respected scientists in your field express a disagreement with you, does that ever affect your position on the subject?
Objection assumes facts not in evidence.
Overruled.
It would if they did, but that has not arisen.
Well, Dr. Weir, is it your position that you have read all the critical comments that have been written either in letters or in publications which disagree with your position on these issues?
Objection assumes facts not in evidence, also calls for hearsay.
Overruled.
I'm sorry, I don't understand that question at all. I have read a lot of material involved in the forensic uses of DNA, but you're asking me to make statements about people disagreeing with what I do, and I would need you to be more specific than that.
Dr. Weir, I just showed you 1205.
Sustained.
You said on direct examination, Dr. Weir, that you have only consulted or testified on behalf of the prosecution. Is that right?
That's true.
And that the only time that you had been invited to testify for the defense, you declined. Is that correct?
The only times, yes.
Now, wouldn't it be also true, sir, that you don't agree with all the methods that are used by forensic laboratories to calculate the statistical significance of a match?
You will have to tell me what you're talking about. I'm not sure what you mean.
Well, for instance, Dr. Weir, you told us that it is your approach to always put a upper confidence limit on these numbers. Is that correct?
I said that, as I said, that goes along with the product estimate, and of course I agree with the product estimate reported by these laboratories and others. I would go an additional step.
And that additional step of a confidence limit will actually make the frequency more common, will it not? As an upper limit.
No, it has no effect on the frequency, of course. The estimate remains as it is, and then we have an upper bound on the estimate.
And the upper bound on what that estimate is a more common number, okay? It's not as rare a frequency as is the estimate itself provided by some of these forensic laboratories. Isn't that correct?
That's true. We keep both things together, but you're true. The outer limit of this interval is more common than the estimate itself.
And you also testified, sir, that you believe that there is substructure within the broader American racial groups. Did you not?
Yes, I think I said that. We certainly expect there to be genetic differences amongst groups, yes.
And that when you make your calculations in a case, that you take this further step to compensate for that substructure. Isn't that correct?
Yes, I do.
And if you take that additional step to compensate for that substructure, that also will make the frequency a more common number, not as rare an event. Is that correct?
Yes, it will, but we should say what effect it has. Putting in a realistic amount of substructuring has an effect which is almost negligible.
Well, let me ask you this, though. But both those approaches, compensating for your approach to compensating for substructure and you're providing the upper confidence limit, depending on the data in a given case, that could be of some assistance to a defendant who is confronted by a laboratory that has chosen not to take either of those two steps. Isn't that correct?
Objection argumentative.
Overruled.
That was long. I think the estimate doesn't change. The estimate remains. The profile has a frequency estimate. That does not change. These additional steps give us some measure of how far apart we might be from the true answer. And of course, we could give I could give a limit the other way. We're only interested in the more frequent. Now, you know as well as I do that the estimate may be a lot more rare than we report. I believe it's a lot more rare than what we report. We are giving the upper confidence limit, not because we are saying the estimate is truly bigger than reported. It could possibly be. It could possibly be a lot less.
So all I'm saying, sir, is that depending on the data in a given case, by providing the upper confidence limit, which you do in each case, and by taking that next step to compensate for substructure, those two steps can make the evidence less rare, or have the impression of being less rare. Would you agree with that?
Not quite. The estimate remains the same. We are attaching a level of precision to it, and we're only giving it in one direction. that direction makes the estimate look more frequent. It's not changing the estimate.
Fine, but you said that direction makes the evidence look more frequent. Is that
That's
correct?
the direction we've chosen to report. We could have chosen the other direction, but that would be foolish, I agree. But this, we're giving half an answer, we're giving the upper limit.
But some of the testing laboratories that testify in court to their results don't do either of those two things that you just described to give a higher frequency. Isn't that correct?
No, that's not quite correct. Cellmark gives confidence limits.
To your knowledge, did Cellmark give a confidence limit in its testimony in this case?
I'm not 100% sure, but I think in some of those reports there are confidence limits reported. I would need to go back and look.
Why don't you take a look at those reports, sir?
I can't, I'm sorry.
To your knowledge, did the Department of Justice offer confidence limits when it gave its numbers in this case?
No, they don't.
Okay. So in those situations, depending upon what the data is, if a laboratory chose, a laboratory used by the prosecution chose not to take those two additional steps, which can create, as you just said, going in one direction, a more common frequency, then your assistance to a defendant or a defense attorney could have some importance, could it not?
Thank you. I take that point.
You agree with that?
I certainly do.
Yet, you have never, in all the years that you have been involved in this issue and testified in cases, even offered to consult without testifying to a single defense attorney on any case. Is that correct, sir?
Well, that's correct, because the defense attorneys don't want me to do that.
Can we stop at this point, Your Honor? Thank you.
All right, ladies and gentlemen, we're going to take our recess at this time. Dr. Weir, you can step down. Please remember all my admonitions to you. Don't discuss the case amongst yourselves. Don't form any opinions about the case. Don't allow anybody to communicate with you, and do not conduct any deliberations till the matter has been submitted to you. Just for your information, we'll be in session on this case this afternoon with just the lawyers. We have 3 motions to take up, so we'll be busy while you're probably out at the movies. So enjoy the weekend, and we'll see you back. I'm going to ask you all, however, just to step back into the jury room for a few moments. I need to take up a few things with the lawyers, then we'll excuse you for the afternoon. All right, have a nice weekend. Withdrawn from the courtroom, Mr. Cochran.
Yes, Your Honor, thank you very kindly.
You said you needed to talk to the court about something?
Yes, I do, Your Honor. Your Honor, yesterday and I guess a couple of days ago, there was a statement made by Mr. Darden at sidebar regarding Mr. Simpson not taking some medication. And that statement was false. And since that time, we've had occasion to had Sean Chapman of my office talk to Dr. Johnson, the L.A. County Jail. And Mr. Simpson has, on every occasion, taken his medication, and the medical records at the jail verify that fact. And I want to, there was a story written about this that's totally nonsensical, medically contraindicated, and I thought compelled as an officer of the court to indicate what the records indicate, what my client has also indicated, that he takes his medicine every day, and that he has never at any time not taken his medicine for his rheumatoid arthritis, sulfasalazine, I think it's called, and that the records at the jail so indicate that, and I think that the record should be made clear in that regard. And we took the further statement, as I said, to talk to Dr. Johnson this morning, who verifies that fact also. So I felt compelled to indicate that to the court.
All right, counsel, our agenda for this afternoon is the people's motion regarding discovery of defense expert statements. We have a people's motion to quash a subpoena upon the various district attorney personnel, and we also have a motion regarding transcripts. Is that our complete agenda for this afternoon? All right, see you all at 1:30. Doesn't matter. parties are again present. We have 3 matters to take up: a prosecution motion for additional discovery, a prosecution motion to quash subpoenas served upon certain deputy district attorneys and district attorney employees, and a motion by the ACLU on behalf of certain press interests regarding transcripts. Let's take up the discovery motion first.
Good morning, Your Honor.
Good afternoon.
I'm sorry, good afternoon.
Good afternoon, Ms. Lewis. Time flies, huh?
I was going to say that, but I didn't think it. Well, I'll keep my opinion on whether that was warranted myself. Your Honor, we have on several occasions already appeared before this court with empty hands, empty of defense discovery, with formal motions asking the defense yet again to give up what the reciprocal discovery laws tells us we have a right to. And we are here once again for that purpose. And I'm here to talk about not just experts' reports, but discovery with regard to lay witnesses as well. Now, first of all, with regard to experts' reports, this court has admonished the defense repeatedly throughout this case that it was skeptical of the lack of experts' reports, that if it discovered or it came to light that their reports either existed or that the experts had somehow been told not to write reports when they otherwise would normally prepare reports, the court has repeatedly admonished the defense that severe sanctions would be imposed. Now, the defense already, for the first time, or the first most egregious time back during opening statements, failed to disclose discovery, which the court found that failure to be an intentional and flagrant violation of the discovery laws, and an intentional one, that they did that for a tactical advantage. That was back in January 30th, I think, was when the court issued its order in that regard. Even after the court at that time ordered the immediate disclosure of experts' reports, we had to come again with palms open and hands empty, asking this court to compel them to do what it already ordered they do. Now, what they did was say that there was some dispute over the extent of experts' reports, some minor issue that could have been resolved without us having to wait weeks for discovery, without getting it, and then have to bring yet another formal motion. That finally got some action on their part. Apparently, that's what caused them to go to the court in camera to determine what they had to turn over. At some point after that, we got rough notes from a number of their experts, rough notes of observations. Still no reports. Now, we're here again, Your Honor, and the court admonished the defense that the last time, I believe, was May 30th, when you told them at sidebar that if it turns out that they were in the wrong and not providing us reports, their experts would not testify. And given their demonstrated failure to abide by discovery laws on several occasions in the past, I think suspicion is warranted. And we are very suspicious. We believe that there are reports that either exist that we should be getting that we're not getting, or that their experts have been called off of writing them somehow. Now, along these lines, Your Honor, I do want to point out that the court seems to feel that there is something improper about the prosecution, and I'm not sure I'm accurate in saying this, so I want to be careful, but there seems to be something improper in the prosecution contacting defense expert witnesses. Now, once they place an expert witness on their witness list, which, for example, they had done with Dr. Reeders back in October of 1994, once they do that, the reason for doing that is that it triggers the reciprocal discovery obligations. It certainly triggers our right to contact that expert, and that's what this whole area of reciprocal discovery is about. So we feel somewhat constrained, and we're in a difficult position. Are we allowed to contact experts whose reports we have not gotten? Or are we not? So long as they're on the witness list, the law I submit gives us the right to contact those experts, and we should be contacting those experts. But the defense wants to argue out of both sides of its mouth, saying that, well, we're not going to have them write reports, so we don't have reports to give you. And meantime, you're engaging in prosecutorial misconduct somehow if you try and contact those experts, if at all. So they can't have it both ways, Your Honor. This is a period and a time and an age of reciprocal discovery. They cannot continue to shield their experts. There is one fatal flaw in reasoning, which the defense still insists on engaging in, and it applies not just to expert witnesses, but to civilian or lay witnesses as well. And that is, let me start by saying that once they have placed these witnesses on their witness list, they have demonstrated under the language of footnote 11 in Izazaga that it is reasonably likely that they anticipate calling those experts at trial. Now that happens as a matter of law. And once that happens, that is what triggers their discovery obligation. There have been statements made in the course of the last few months by Mr. Blazier, Mr. Scheck, and others that demonstrate apparent ignorance or an unwillingness to follow that mandate, because they still demonstrate this subjective intent idea, where if they end up not calling a witness, an expert witness or any other witness at trial, then they don't have to provide discovery. But they've missed the whole point of reciprocal discovery. While the reciprocal discovery is not designed to force them to call a witness to trial, it is designed to provide the prosecution with an understanding and a full knowledge and opportunity to cross-examine intelligibly, because we have knowledge of their prior reports and what they would basically testify to. Now, they do get the final decision on whether they don't call that witness at trial, and that assumes, of course, that this court does not preclude them because of discovery violations from making that decision. But that doesn't mean they can withhold the discovery for those experts who still to this day remain on their witness list. When it comes to experts, to this day, with the exception of a report, a 4-page report from Dr. Gerdes, which we did get this week on Monday or Tuesday, with the exception of that, we still have not gotten a report from any of these numerous experts that they discussed in length at opening statement and have been the subject of 2 or 3 previous motions to compel their discovery. We still do not have those. Now,
Do you feel I need to go beyond the previous order?
I do, Your Honor. I believe at this point in time there is good cause, considering the past findings of this court and the past orders of the court with regard to discovery, to force the defense to make an affirmative showing that they are not doing something underhanded or unethical with regard to their discovery obligations, to force them to show that they are indeed complying with the law in this regard. The court's earlier finding with regard to the failure of the defense to turn over the witnesses that Mr. Cochran mentioned during opening statement indicates that they were not that they are not unwilling to engage in that kind of conduct. And that was what we started off with back in January, where they intentionally withheld, and the court made a finding that they intentionally withheld discovery on those witnesses for no good legal, ethical reason, but only to gain a tactical advantage. And the court issued some strong sanctions in response to that in terms of allowing us to reopen and admonishing the jury, and those sanctions were appropriate. Now, Your Honor, I've been before this court a number of times on this issue. I've never yet before now, and I am asking now, for you to preclude them from calling any expert for whom we do not have a report and for whom they cannot provide a satisfactory explanation that the court believes and the court gives credibility to as to why they don't have that report and whether they're getting that report and when they're going to get that report. Because it's been on the table now for months and months that these experts would normally, it's everyone's expectation that an expert writes the report. That's what everyone expects, prosecution, and I won't speak for the defense, but that is the expectation. Now, if I may, I want to mention there's a problem with regard to civilian witnesses or lay witnesses. The prosecution and the defense early on in this case had an informal agreement that we would not exchange attorneys' notes of witnesses. That agreement was not, to my knowledge, and I've looked and thought about this, it was never finalized, or formalized, I should say, with regard to the defense's obligation to provide witness statements that their attorneys took, as opposed to their investigators. Now, we, on the other hand, the prosecution did, because of global discovery demands, enter into an understanding with the defense, which we embodied in a document which we gave the court a copy of earlier, in which I've included the relevant page for in an appendix to the brief. We did formalize that aspect of discovery, whereby the prosecuting attorneys did not have to turn over their attorneys' notes of witnesses. The reason for that, and the common sense behind it, and the reason why that is okay, that we are asking for their notes, even though we're not turning over ours, is because in every instance where witnesses testified, we have had a police detective or a DA investigator interview that witness and write it up in a statement form, coherent statement, and have given that to the defense so that they have that, so that they had no need for attorney's notes. On the other hand, there are a lot of civilian, as opposed to expert, lay witnesses which the defense has failed to give us any information on at all. And there are also, in addition to that, approximately 10 or 11 witnesses for whom they have provided only rough notes. And I made a copy of those. I know I appended one to our brief, but I did make a full, I believe it's a full set for the court's perusal with regard to the other witnesses that I didn't append to the brief, to show the court just how loose these notes are and how unreliable they are. We cannot rely on these. We cannot rely on these in either of two ways. One, we can't rely on them for notice of what the witness is even going to say. Most of them, many of them do not even include relevant dates or time periods or what it is exactly they're alleging. You have to try and read between the lines. So there's an obvious due process problem, which is not satisfied by these notes and which does not satisfy the discovery statute. In addition, there is the problem that we do not have anything concrete upon which to cross-examine these witnesses for whom we've been provided either no discovery or these rough notes. We cannot expect a witness to testify consistent with something that is incomprehensible. And so therefore, if the witness testifies differently from what they said, we're not going to know it because you cannot tell from these notes. Therefore, there's nothing in these notes with which we can impeach them. So that provides almost nothing. The only thing it gives us is some rough idea of the nature of the subject matter of the testimony. It does not tell us what they would say, what their statement would be, what it is that they believe to be the truth that they would testify to. So for the defense, on the one hand, to say, well, we have this agreement where we're not going to give you attorney's notes, but on the other hand, either withhold discovery entirely on many witnesses or give us only these inadequate, undecipherable rough notes with regard to these 10 or 12 witnesses, it's just not fair. They just don't come into court in equity with clean hands and be able to force us to abide by that early informal agreement because they have not abided by the discovery laws and the spirit of that agreement, whereas we have in providing them witness statements from police or DA investigators with regard to all these witnesses. So we believe, Your Honor, with regard to the lay witnesses or non-expert witnesses, they should be required to either have their investigator write a coherent, I should say, an understandable, intelligent, understandable statement with regard to what these witnesses would say, or give up their notes. I mean, they cannot shield themselves with this informal agreement we had earlier when they're using it to violate the discovery laws. I have to bring to the court's attention one final matter which is not discussed in the brief. Mr. Douglas and I had been discussing the availability of certain photographs and certain negatives of photographs, and I believe apparently we've reached an impasse with regard to them. There were photographs provided to the prosecution which included those taken at Mr. Kardashian's house on the 17th, as well as those taken at Dr. Heisinga, I believe it's pronounced, office on the 15th. Now, those photographs...
You've been provided copies?
We were provided copies, I guess, as far as we know, of all those photographs, but apparently they were lumped together. The other day I came down and asked Mr. Douglas and Mr. Shapiro, who was the only other defense attorney who they thought would be knowledgeable on that, to try and separate out those which were taken at Mr. Kardashian's house from those that were taken at Dr. Heisinga's. And Mr. Douglas and Mr. Shapiro were able to do so with regard to about 2/3 of those photographs. There still remain a set or a bunch of them with which they could not distinguish. Consequently, I asked if we could be provided with the negatives of Dr. Heisinga's photos. The reason for that request is because we had previously been informed, apparently I'm told, that they had lost the negatives of the photographs taken at Kardashian's house, Mr. Kardashian's house. So consequently, if we got Dr. Heisinga to bring in his file, which presumably would have the negatives that he took, so that we could go through the negatives and make copies for ourselves off of the negatives, which would provide much clearer pictures of the defendant's cuts and so forth, than do the photos, apparently photos of photos, which we have. So one, for that purpose, and two, for the other purpose of separating out, so that we would know exactly which photos were taken at which location on which date, because as it stands, they were all given to us, apparently given to us together. Lastly, Your Honor, there were discovery documents given to us, which we acknowledged receiving last Tuesday on the 20th, included within those documents are handwritten notes from Dr. Henry Lee, which were made apparently on April 2nd, 1995. That's when they're dated. And they are notes of his observations, apparently, and perhaps others' observations, that's what they appear to be, of various aspects of the SOX, which are an issue in this case, as well as apparently some have to do with the Bruno Magli shoes as well. Throughout this discovery is mention that photographs were taken, including, and of particular importance, that this says micrographs. So apparently there were micro photos taken is what I'm trying to get to. And we have not seen those, and we believe we have the right to those. And we may have a disagreement about that. I believe we probably do have a disagreement about that. I broached the subject on that particular issue before our lunch today, and I think we do have a disagreement. But whether or not the defense intends to offer those photos as real evidence at trial, I think if they, given their placement within all these observations of apparently Dr. Lee, we have a right to those photos as part of the observations of experts and notes of observations of experts. And we have received many photos in this case along similar lines, where apparently photos which were taken during the course of an examination from an expert, by an expert, were turned over to us. So that is our position on that. But once again, I'm tired of coming before this court. I'm sure that the court is tired of hearing me. I'm sounding like a broken record with regard to our frustration at having the defense flagrantly, what appears to us to be flagrant violations of the discovery laws, because we have simply not gotten what one would expect given all the reciprocal discovery laws, mandates, and the case law following it, and what the magnitude of this case would dictate.
Thank you. Mr. Uelmen.
Thank you, Your Honor. I can state without equivocation, without reservation, that all reports that are in existence for any of the experts on our witness list that we intend to call as witnesses at this trial have been turned over.
So the only expert witness you intend on calling at this point is Dr. Gerdes?
That's not what I said, Your Honor. I said all reports in existence prepared by any of the experts we intend to call have been turned over. Some of the reports that some of the experts that we intend to call have not prepared reports, and we have not requested them to prepare reports. And that, I think, is where we part company with the prosecution's interpretation of the reciprocal discovery law. Reference has been made to the whole point of reciprocal discovery. The whole point of reciprocal discovery is simply acceleration, not disgorgement. The whole point of reciprocal discovery is to make available to the other side the materials that you have prepared in putting your own case together, that you are going to put on as evidence in the presentation of your case in chief. The discovery law does not impose any obligation to prepare reports or statements. It simply requires the turning over of the reports and statements that are prepared in the routine of the preparation of your case. Now, Ms. Lewis has stated everyone's expectation is that experts write reports. I'm afraid that's just not true. That is not everyone's expectation. In fact, the prevailing practice among many, many defense experts is that they will not prepare reports unless they are specifically requested to prepare reports. Now, Your Honor, of course, is aware of the Sarah case. We're aware of it too, in which a court held that for a defense lawyer to instruct a witness whose routine practice was to prepare a report not to prepare a report, specifically to avoid having to turn that report over in the course of reciprocal discovery, was contempt. But that case did not hold that there was any obligation for the defense to make sure that a report is prepared by every witness that they intend to call as an expert witness. And quite to the contrary.
Gentlemen, let me ask you this. Forgive me for interrupting you, but it would be my impression, let's take, for example, Dr. Lee, that it's the practice of Dr. Lee and his office in the state of Connecticut to routinely prepare reports on the cases that they consult on and the cases that they assist the state authorities in that state to prepare for trial.
I think Dr. Lee will speak to the contrary on that point, that when he is retained by the defense as a consultant, he does not prepare reports unless they are requested. And Dr. Lee is an excellent example because his relationship has been an ongoing consulting one in which he is frequently consulted as the evidence develops on an ongoing basis by the lawyers representing Mr. Simpson for the defense. It is not the practice to require him to put into a written report the results of all of his consultation. And at this point, we have not even made a determination yet as to what issues Dr. Lee will be called to actually testify as an expert witness. So the discovery law doesn't say to the defense, you have to prepare reports. It simply says you have to turn over the reports that you do prepare. So the question, and again in our moving papers, we have cited a case from the Ninth Circuit, incidentally the same court that decided the Sarah case, the case of United States versus Peters, in which the court reversed the imposition of sanctions of excluding an expert because a report had not been produced on the grounds that a report had not been prepared. And under the federal discovery law, which closely parallels the California reciprocal discovery law, there is simply no ruling by any court at any time that a court has authority to order the preparation of a report so that it can be turned over. And there's good reason for that, Your Honor. If that were the case, if the reciprocal discovery law were to say to the defense, you have to produce reports and statements so that they can be turned over to the prosecution for their use, we would seriously run afoul, I think, of the protections of due process. The whole concept of reciprocal discovery is not based on turning the defense into agents who are supposed to assist the prosecution in investigating the case and making evidence available to them. The whole concept is simply we want to accelerate the process and say to the defense, if you're going to put this stuff on in your case, then you're going to waive whatever privilege protects it anyway. Therefore, you might as well turn it over now so that we don't have to delay the trial, so that the prosecution doesn't get this stuff when the witness is actually called to the witness stand. The extent, I think, of the prosecution's misconception of the reciprocal discovery obligation is implicit in their position, in their moving papers, that simply putting a witness on the witness list means that automatically the defense has to turn over anything obtained from that witness, even if they thereafter elect not to call that witness as a witness. That somehow just putting the name on the list works as a total waiver of any privilege that might protect the information that witness later turns over to the defense. And that is simply not the law. In fact, that position was explicitly rejected by the Court of Appeal in the Rodriguez case that we have cited, in which the court held that even after you put your witnesses on the list, at the time a later report is produced, that report may be excised to exclude privileged material as to which that witness is not going to testify. And the Woods case, which is the only case cited by the prosecution for this remarkable proposition, held that in that case, because the defense had turned over a report, at that point, the contents of that report were waived. Now, I'm not suggesting that we have reports that we're sitting on, waiting to see what our experts are going to actually be called to testify to. We concede that as long as our experts remain on the witness list and we receive reports, and our intent is to put those experts on the stand to testify as to the information in those reports have to be turned over as soon as we receive them. And we are certainly going to do that. But if at any point we decide to withdraw an expert and not have that expert testify, at that point, any reciprocal discovery obligation disappears, because the only purpose of the reciprocal discovery obligation is to accelerate the presentation of what is actually going to be presented by putting the witness on the stand. It is not to make available to the prosecution some sort of windfall of new information that they might then put to use in terms of supporting their own flailing case in chief. With respect to the rough notes of the witness statements, we have turned over the rough notes because that's all we have. And again, there's no obligation that we instruct our investigators to go out and interview a witness and prepare a statement simply so that statement can be turned over to the prosecution if we don't need the statement in order to prepare our own presentation of that witness. So again, it's a consistent position in that respect. We have been accused of playing fast and loose with the reciprocal discovery law. And quite to the contrary, Your Honor, I think all of the cases that have interpreted this law have sent warning signals that we are treading on very dangerous thin ice from the perspective of the defense lawyer's obligation to protect the privileges that encompass the presentation of or preparation of evidence for the defense, and to proceed with great caution in terms of what you turn over, because once you turn it over, it's a waiver, and the cases make that quite clear. Once you turn it over, whether you put the witness on or not, you have waived the privilege. So it's incumbent on the defense to very carefully look at what we're turning over. And we are proceeding on that basis. And we have turned over all of the reports that we have received from the experts that we have on our witness list and intend to call as witnesses in the defense case. There may be witnesses who are on our witness list who will not be called. But the fact remains, until we have received a report and we intend to present that witness to produce the results of that report, there is no obligation to turn that report over to the prosecution. And there is no authority.
Wouldn't you say we probably cross that line when you issue a subpoena or have an agreement for that person to appear or be on call as a witness?
You know, I'm not even sure that a subpoena crosses the line in terms of
Isn't that likely?
requiring that witness prepare a report. What I'm saying is, even up to the point that they've taken the stand and been sworn, there is no obligation that they prepare a report simply so that it can be turned over to the other side. If we're prepared to put our witnesses on without reports, knowing that there's a risk, certainly they can get up and cross-examine, and they can say to our experts, "Doctor, did you prepare a report?" "No." "You mean you did all of this investigation and came to these conclusions without ever writing a report?" "Yes." And they can compare that expert testimony to the expert testimony that they presented and suggest to the jury that this expert presented by the defense perhaps is less credible because he didn't prepare a report. That's certainly an avenue that is open to them. But what I'm saying is, that's a decision that is our decision, and the law does not in any way implicate our right to make that decision, to say that we are prepared to put our experts on without having required them to prepare reports. Finally, we would note that everyone's expectation that experts write reports. Dr. Lakshmanan never prepared a report. I think we're dealing here with a case in which the recent developments indicate just how fluid and dynamic the tactical decisions facing the lawyers trying this case are, and how in many cases those decisions are going to change as the evidence comes in. So it's certainly not our expectation that all experts write reports, and it should not be the expectation of the prosecution as well.
All right, any brief response, Ms. Lewis?
Yes, Your Honor, thank you. The defense is still laboring under this misassumption, and this is where we radically depart from the meaning of the discovery laws. They're under this assumption that they can wait until they finally, decisively, actually call Mr. Witness X, Dr. X, to the stand before they have to before they've conclusively decided they're going to call that expert and therefore turn over a report. And again, when Mr. Uelmen talks about not knowing exactly what subject matter Dr. Lee is going to testify to, he's making that same argument again. And that argument cannot be the law, because every defense attorney in every case could argue that and could thwart the whole purpose of reciprocal discovery when it comes to experts. There's a real problem with that attitude, and I don't think it flows. I think it's a matter of law. The law is to the contrary. Once they put the witness on the witness list, they've done that.
Do you have a case that says that?
Well, under Izazaga, footnote 11, when they reasonably anticipate calling a witness at trial, I think putting them...
Do you have a case that interprets that phrase?
No, I don't believe there is one in California. But I think...
So how can it be so clear? And is there a federal case that has an analogous statute, or the Oregon statute that has a case that says that that's what reasonably likely to call?
No, Your Honor. The Parker case that Mr. Uelmen alluded to, which relied on the federal rules as well as a Hawaii statute, the wording of that statute, which the court interpreted the plain meaning of, explains that decision. The federal rules as well as the Hawaii local rule, in terms of discovery of experts' reports, provide that the defendant shall permit the government to inspect and copy or photograph the following. Then they list experts' reports and so forth. And what the Ninth Circuit said in the Parker case is, because the statute says it shall permit the government to inspect and copy or photograph it, it must have been making reference to something tangible already in written form. And hence there is no obligation under that statute to reduce an oral communication to writing. We don't have, our statute is not worded the same. Consequently, its plain meaning is different from the plain meaning of the wording of this statute. They're not analogous. In addition to the statements of experts that our discovery statutes talk about, they talk about the defense having to provide the results.
No, excuse me, maybe I obviously didn't make myself clear. My question was reasonably likely to call as a witness. What triggers that standard? What is that standard? Is it when a subpoena is issued? Is it when the actual witness list is prepared? Do you have any case authority that defines that term?
I don't have any, there is no authority that I'm aware of that specifically delves into that issue. In Woods, however, the court does address it. The court addresses the defense argument. There is no case, I believe, in California that specifically defines that yet, that discovery law is still being interpreted.
I was wondering if you found anything in the federal statutes or the Oregon statute.
I have not, Your Honor.
Right.
The Woods case, in the Woods case, you know, it's still right on point where it says, finally, the defense protests the vice of acceleration is that disclosure must be made solely to preserve the option of calling the witness, even though not all reasonably anticipated witnesses are actually called to the stand. At least in the case of confidential statements, the public defender in Woods argues there should be no waiver until the expert testifies. And the Court of Appeal in Woods held, we sympathize with the position, but cannot accept the argument as a general proposition without doing damage to the statutory objectives of ascertaining the truth, saving time in trial, avoiding the necessity of postponements, and protecting against undue delay. So the Court of Appeal, the policy behind requiring the defense to disclose those witnesses it reasonably anticipates calling at trial is to require that discovery to be turned over. So while there's no case which construes it specifically as far as what the court is talking about, there is the whole policy of the law, and the policy is explicated as it is in Woods and other cases. I'm reminded apparently that there have been defense experts going on national television saying they will testify in this case. I seem to recall Dr. Lenore Walker saying that on a Larry King live show.
Have you received any of the underlying testing information that was
We did, Your Honor,
discussed?
shortly after the court ordered it. We received, or informally ordered it, or maybe it was formal. We did receive, I know that. We have received the raw data of the testing results. We have never yet received any kind of report from Dr. Walker with regard to her analysis or interpretation or anything of that data. And we are wondering, why isn't that forthcoming? If she's bragging on national TV how she's going to be testifying in this case, surely she must have an idea of what she's going to be testifying to. So, Your Honor, the discovery law requires this disclosure so that those things can happen which it seeks to promote, and that is the ascertainment of truth, to save time and from delays happening or necessitated because of the failure to provide timely discovery. So all those things warrant the court finding that by placing these witnesses on their witness list, they did that for the purpose of preserving the right to call them. So therefore, it demonstrated as a factual matter that they reasonably anticipated calling them for trial. I've argued that my reading of the statute, that should be as a matter of law, but it's also as a factual matter, and the court can so find with regard to this case, that they made that factual determination. Otherwise, why would they put those witnesses on their witness list? They clearly did so because they wanted to preserve the option of calling them, because it was reasonably anticipated, and that's the loose language of Issazaga. It's not strict language, it's very loose language. They reasonably anticipated calling them at trial. It was likely they would call them at trial. And Issazaga does establish the standard to that extent that it allows for a looser standard than the near certainty or certainty that Mr. Uelmen argues to this court should be required before they have to disclose statements. Now, when they talk about civilian notes and so forth, oddly enough, throughout most of the several months of the beginning of this case, the defense was, when they eventually provided them, we didn't get them timely, but when they finally gave us witness statements, their investigators were able to write coherent statements. Many of them were short and to the point. They were not, most of them, the ones that we have gotten, are not lengthy, detailed, complicated things for an investigator to write out. So it's strikes us as suspicious, and it is suspicious that why is it now suddenly with these last 10 or 12 witnesses that we get all these rough notes on, why are we only getting rough notes now if that's their general practice and procedure? Why haven't they been doing that all along? They've been writing statements all along, and their investigators have been writing statements of witnesses all along. Suddenly now there's been a change, and we're getting only these rough notes which are incoherent, and we're unable to rely on them. So we believe we deserve more, Your Honor, and I'm here again with my palms open asking the court to please enforce the discovery laws and require the defense to do what the law obligates them to do.
All right, thank you, counsel. I accept as a premise in this matter Mr. Uelmen's representation to the court at this time that all expert witness reports that have been produced and that are in the possession of the either the expert witness themselves or in the possession of defense counsel have been turned over to the prosecution of those witnesses that they intend on calling, that the defense intends on calling. I have already expressed to counsel my skepticism that so many defense witnesses would not prepare reports, especially given the national stature of so many of these witnesses. It seems unlikely to me that that's the case. However, I do acknowledge that this trial has been very dynamic and very fluid in the way that it has progressed, and that things change day to day, moment to moment. And I can see clearly strategies shifting on both sides. So whether or not a final determination has been made to call a particular witness, I can, as a former trial lawyer, understand that that decision changes from day to day. The prosecution, Ms. Lewis, you make the argument that I should look to the policy and the spirit of the statute and enforce the policy and the spirit. The problem is the policy and the spirit is for the appellate courts to determine, not for the trial court. I'm bound by the particular language of the statute, and as a trial court judge, I can't go beyond the statutory language. There are many flaws in 1054 of the Penal Code, and I suspect one of the outcomes of this particular case, no matter what the outcome, will be a legislative change in 1054 that will statutorily require the preparation of reports. But that's not supported by the case law, and it's not supported by the statute. The court's previous order does direct the defense to turn over all reports as soon as they become available. That order stands. And I previously warned the defense that if expert witnesses are called and if I find that there's been a subterfuge, those witnesses will be precluded. That ruling stands.
Thank you.
All right, let's go to the motion to quash the subpoena. All right, Mr. Darden, good afternoon.
People have filed moving papers seeking to quash the subpoenas for Melissa Decker, one of my personal law clerks, and Deputy DAs Alan Yokelson and Terry White. While it's true that the defense can issue a subpoena on a hope and a prayer that the witness will appear and provide them information, a witness isn't obligated to appear and testify unless the defense can establish or make a showing, rather, that the witness can offer some material or relevant and admissible information. In this situation, as I understand it, these staff members of the DA's office can offer the defense nothing at all in terms of material information or evidence or testimony. They have nothing to offer this court or these defense lawyers in the way of anything that is relevant to these proceedings. Apparently, the defense hopes to somehow impeach Mark Furman's testimony, and I can understand why they might want to try and do that. He was a very effective witness. He did not buckle under the pressure, and I'm sure that the jury found him a very credible witness. Now, they seek to undermine that testimony by calling these DA employees. Their offer of proof, or the showing that they intend to make, apparently is based on an article in Newsweek magazine, specifically a March 6 article. They've cited that article or quoted a portion of it to the court in their response to our motion to quash, and I would ask that the court take a close look at that article. It provides no source, no named source for the information contained in the article. It doesn't even say that the source is anonymous. In fact, no source is mentioned at all. There are a couple of quotes contained in the article. One of the quotes is attributed to a source close to the prosecution, not a prosecutor, not a member of the DA's staff, but a source close to the prosecution. And then that individual apparently, and that is if you can believe the Newsweek writers, goes on to state that Mark Furman was a difficult or defensive witness during an alleged mock cross-examination. Well, let's say that's true. Let's say that Furman was difficult and defensive. Well, that's an opinion. That is the opinion of the source close to the prosecution, and if that was the opinion of any member of my staff, then that opinion is privileged. It's not relevant. It's not
Privilege under the work product privilege?
under the work product privilege. It would not be admissible. There's a second quote that's attributed to a prosecutor familiar.
We're not talking admissibility, we're talking discoverability.
Okay, I understand that. I understand that. But it wouldn't be material or relevant as well.
Well, there's different standards for discoverability and admissibility.
Yes, Yes. There's a second quote, which is attributed to a prosecutor familiar with the case. And that person, assuming he is a prosecutor, assuming he is familiar with the case, and I doubt that anyone is really familiar with this case unless they sit here every day with us and witness what goes on in court. That prosecutor speculates that if the information contained in the article is true, that a jury might conclude that Mark Fuhrman planted evidence. Well, how is that material irrelevant or admissible? It isn't attributed to any member of my staff, and it isn't attributed to the DAs and DA staff members that they seek to subpoena. Nor, given the context of this information, given the fact that it is from some unnamed source, assuming that there is a source, nor is it likely to lead to evidence, discoverable evidence that will be proven admissible at some later time. There's nothing in the article to suggest that we as prosecutors are in possession of any information that is inconsistent with Mark Fuhrman's testimony. They make these base allegations, of course. Of course they do that. But they don't attribute those allegations to us. Now, we as prosecutors have a duty, I think, to advise the court in the event that a witness testifies in a manner that would constitute perjury. And I understand the perjury statutes in this state. I have indicted police officers on perjury allegations. I have investigated police officers for perjury. I have participated in Board of Rights hearings on perjury issues, and I understand the law on that. And I suspect that what the defense really wants to know is whether or not Mark Fuhrman told us that he used the N-word in the past 10 years. He testified that he did not use the N-word in the past 10 years, and had I any information otherwise, I would have advised the court. And I have not advised the court because that situation has not arisen. Now, counsel for the defense and the prosecution have entered into an agreement, which was alluded to by Ms. Lewis a moment ago, and that is that attorneys' notes are not discoverable. I think that if we look at the spirit and the purpose of that agreement, if our notes aren't discoverable, why then are our thought processes discoverable? Why should we be required to come and testify under circumstances like these? It turns the agreement on top of its head, on its head. We have nothing new to give the defense. We have nothing to tell them that they don't already know, that they don't already have in discovery. If they want to know if Mark Fuhrman ever used the N-word throughout his life, then they have the same 1981 and 82 psychiatric reports that we have. We discussed that before. Okay, and the court ruled that that evidence was irrelevant and inadmissible. We don't have anything else new. As for the article's characterization of that event as a mock cross-examination, and I want the record to reflect this so that it is understood, when Mark Fuhrman was here on one weekend, the air conditioning in the upper floors in this building were turned off. We had to go to the only floor we could go to where the air conditioning was on and where someone had a key that happened to be on the 13th floor. And when we walked into the grand jury room that day, I said, geez, I'm going to regret this one day. And we have. But at any event, we have no new discovery, Your Honor. My staff has nothing to offer this case, these defense attorneys, no new evidence whatsoever. And I'd ask that the subpoenas be quashed. They cannot show this court that we have material, or relevant, or admissible evidence.
Thank you, Mr. Darden. Mr. Uelmen.
Your Honor, to put these subpoenas in context, all three of the subpoenaed individuals, we have information, were present during this unusual Sunday afternoon grand jury session with Detective Mark Fuhrman. Detective Fuhrman, Your Honor will recall, was questioned about this session during his cross-examination when he appeared as a witness in this trial. And he testified that the session was a very brief one. He said 20 to 30 minutes, that it was very casual, that he was eating a submarine sandwich while various questions were discussed. And to quote his testimony from the transcript, page 18768, by Mr. Bailey, "Can you tell me, just yes or no, were any racial slurs used in that experience that day?" Answer, no, there weren't. Question, not a single one? Answer, no. Now that varies significantly from the description of this session that appeared in Newsweek magazine. And I call your Honor's attention to the quotations that are attributed to district attorney sources in their description of what happened in that Sunday afternoon session. The attorneys were hammering Detective Mark Furman as the questions turned to the issue of racism and to his disaffection as a police officer. Furman became uncomfortable. He admitted that he had made racial slurs in the past. He conceded he was profoundly disappointed in a criminal justice system that too often fails to punish the guilty. Furman played right into the hands of the defense. This time, the interrogation of Mark Furman was only a dress rehearsal. It took place, Newsweek learned, during a mock cross-examination staged by the prosecution last week when the Orenthal-James Simpson trial was in recess. The article goes on to say, quote, "A source close to the prosecution said Furman came across as a difficult and troubled witness, that he became defensive and agitated." The article then asks, could Furman's performance help a juror believe that the detective had planted the infamous bloody glove at Simpson's Brentwood mansion? That wouldn't be a big leap, says a prosecutor familiar with the case. Now, when a national news magazine cites as their source individuals on the staff of the district attorney's office.
What anonymous? What credibility can a court put in anonymous sources?
Well, the question, Your Honor, is whether we now have enough of a basis to pursue this and ask to speak to the district attorney personnel who were concerned, and if they refuse to speak to us, to subpoena them as witnesses.
Well, Mr. Uelmen, let's assume that if a witness statement is made to a prosecutor, and that statement contradicts testimony in court, and let's assume that I believe that there's a Brady obligation under that scenario to disclose, how does the court, and assuming further that we have the unusual situation that you're talking about calling deputy district attorneys involved in this case as witnesses, so I have the same problem only in reverse of the Kardashian situation, how do you suggest I deal with that?
Well, there are
And
a number of...
this assumes that I find Newsweek to be a credible source of information.
Right. There's one important distinction, and that is that with respect to Mr. Kardashian, there is an attorney-client privilege with respect to the consultations between Mr. Kardashian and Mr. Simpson.
No, we're not talking about that situation.
Well, here we're talking about a mere witness. We're not talking about any implication of any lawyer-client privilege.
No, I'm asking you, how do we proceed? You're missing the point. In both situations, you're asking to call as a witness in this trial counsel for one side or the other.
Right.
That raises very delicate issues, I think. Because,
I would
say, for
suggest
example,
that Your Honor proceed the same way you did with Kardashian. We made Mr. Kardashian available to the prosecution to be interviewed.
But if you're not, Your Honor, I have to interrupt. I'm sorry.
no, you don't need to interrupt, Ms. Wilson.
Well, I believe that there was an effort made to ascertain precisely what it was they wanted to ask Mr. Kardashian. We are simply asking that we be given the opportunity to talk to the prosecutors and to the district attorney personnel who were actually present during that session. That session is not a privileged consultation. We're not asking to impede on any work product privilege. We're not going to ask these witnesses what their thought process was or what their evaluation of Mark Furman was. We're going to ask them what happened and what was said in that session that could conceivably contradict and impeach what Detective Furman testified to when he was called as a witness at trial. And I think Your Honor is correct that there is a Brady issue lurking here. In fact, if what the Newsweek article says is true.
Well, why don't you address my specific question? How do you propose the court proceed as making those assumptions?
Well, I would suggest the court proceed by ordering that the district attorney personnel that we have subpoenaed submit to interviews by the defense. We have requested an opportunity to interview them, and the response was simply they are overburdened. They're too busy to talk to us. We believe if they're going to stonewall us and attempt to cloak this entire session in the grand jury room with some sort of impenetrable wall of secrecy, then we have a right to bring them into court and out of the jury's presence question them. I think that would be a ludicrous use of this court's time to have to go through that exercise simply because they won't sit down and even talk to us. Now it may be, and we'll assume that when they sit down and talk to us, they're not going to lie to us, just as we assume they're not lying to Newsweek magazine. If they're going to give us information about what happened, not their impressions, not their notes, just simply an account of what happened in that session, it may be that we don't even need to call them, that there is nothing there. But the published account attributable to sources in the district attorney's office suggests that there indeed may be something there. Certainly enough of a suggestion to create an obligation on our part that we pursue it. And that's all we're attempting to do. The subpoenas are a product of the attempt of the district attorney to simply stonewall us and say, we're not even going to sit down and talk to you. We're not going to make these personnel available to be interviewed because they are overburdened. And I think that just strains credulity.
What is the return date on your subpoenas?
They expired long ago, Your Honor.
Well, it's not going to make it moot in the sense that it won't recur. We'll just have to re-subpoena them if the date of return has expired. But I think the simplest solution to this problem is simply to permit us to interview these personnel.
And the specific issue are statements made by this witness that are contrary to the testimony here in court.
That's correct. That's what we want to inquire into. What statements were made in the course of the grand jury interview and prep session that would contradict his testimony at trial.
Right.
The questions would simply relate to their observations of what occurred in the grand jury room.
Recognizing that there's attorney work product interwoven throughout that. It's not that, I don't think
Well,
it's
we're
that
not
simple.
we're not interested in the attorney work product. We're not interested in their impressions. We're not interested in whatever notes they were working from in terms of questioning the witness. This is a legitimate pursuit of evidence that is highly relevant and highly probative as to the credibility of one of the key witnesses who has testified in this trial.
Thank you, Mr. Uelmen. Mr. Darden, do you have any brief response?
Briefly, Your Honor, we understand our Brady obligations, Your Honor, and we have met them. I'm just surprised to hear that the defense feels that if their experts go on TV and say they're going to testify, that they don't have to produce a report. But if a magazine writer writes an article using unnamed sources, we somehow have an obligation to provide them, to provide ourselves to them and submit to an interrogation by the defense. That is simply ridiculous. We have nothing at all to offer this jury or this court, or this defendant and his lawyers regarding Mark Furman. As far as the description of what happened in that mock cross-examination, they say they want to know what happened. They heard the testimony. They saw the witness. Okay. So they know. Now they know a little bit more because I've told them a little bit more. It would be unfair, completely unfair, given the agreement that we have with the defense and given this fishing expedition that they want to go on, to require us to submit our clerks and our special assistants and our lawyers and our staff to a defense interrogation. It's unfair. I'm sure it is unprecedented, and we object.
Thank you, counsel.
Your Honor, if I could just call the court's attention to one portion of the record. Mr. Darden says that everything that went on in that session we learned from Detective Furman. I would invite the court's attention to page 18764 of the transcript. Question by Mr. Bailey. Can you remember even one of the questions that these three lawyers put to you? Answer, no, I do not, sir. Question, not a single one? Answer, no.
Yes.
Sure.
Ms. Lewis advises me that questions are work product, but can I also give the court an additional citation?
Questions may be work product, but the answers given to them are not.
And that citation is People v. Hollander, 194 Calat 2nd, 386,
What does that stand for?
page 391. It stands for the proposition that the defense can't subpoena witnesses in the hope that those witnesses might somehow impeach a prosecution witness. It stands for the proposition that they have to show that the witness has some material relevant and admissible information. And as for Mr. Kardashian, I think the court understands the factual distinctions in his situation.
All right. Another interesting situation we have here. Counsel, first of all, as a beginning premise, I accept that the court does have the power and discretion to quash subpoenas in situations where it's appropriate to do so. But this is a matter of discovery at this time, not a matter of admissibility. And I agree with the defense argument that given the publication in a nationwide, a magazine of nationwide distribution that is considered to be a news source rather than a tabloid type source of information, that triggers an attorney's obligation to conduct further investigation by means of the discovery process, and I accept that as a given. I also accept that if a witness has made statements to counsel during the course of preparation statements that are contrary to the testimony in court, that is discoverable. And because of the parties who conducted this questioning, it also becomes discoverable under the aegis of the Brady Doctrine. So I find it that there is a sufficient prima facie showing that there is potentially discoverable information available through Messrs. Yokelson, White, and the law clerk, Miss Decker. But I also recognize that these are counsel for one of the parties here, which is a touchy situation similar to the Kardashian matter. And the court will therefore conduct in camera its own questioning of these persons. However, I'm going to request from the defense recommended questioning of these witnesses. I'm going to direct Mr. Yokelson to appear in this courtroom on Tuesday, June 27th at 8 a.m. I'm going to direct Cheri White to appear in this courtroom on Wednesday, June 28th at 8 a.m. and Law Clerk Decker on Thursday, June 29th at 8 a.m. And the court will conduct in-camera questioning of these individuals on the record.
Your Honor, if I can indicate this, Ms. Decker is studying for the bar exam.
Bad timing. Okay.
At this time.
That is, all right, why don't you find out when she'll be available?
Okay. And as for Mr. Yokelson and Mr. White, can we have additional time, approximately 1 week before the court begins its...
Why do you feel that's necessary?
So that we can consider appellate remedies, Your Honor. Obviously, the court will give us until Wednesday to come back and advise the court of whether or not we intend to seek an appellate remedy.
Well, I would imagine that whether or not you're going to seek appellate remedy is something you can decide between now and Monday, don't you think?
I said Wednesday.
I know, I'm saying, but don't you think you could figure that out between now and Monday?
It's 2:30 on Friday afternoon.
Well, I assume that the district attorney's personnel work until 4:30 on Fridays.
This district attorney works until, well, hours much
All
longer
right.
than 4:30.
Counsel, we'll do this. I'm going to direct the defense to submit to me a recommended questioning by Monday the 26th. Mr. Darden, you can come in and tell me what the prosecution's position is on Monday. If you feel appellate remedies are necessary, then I will consider a motion to continue the hearings of the 27th and 28th. All right, and then find out when Ms. Decker will be available. And my anticipation is that these hearings, in-camera hearings, will take approximately half an hour, is my guess at this point.
Okay.
All right, that's the order of the court. All right. Mr. Morrell.
Regarding the questions that'll be proffered, are we going to be allowed to take a look at the questions?
Oh, yes, absolutely.
Thank you.
Your Honor, before we embark on the transcripts, I do want to ask the court to at least take under submission the ruling on the photographs. Apparently, the defense is not willing to provide Dr. Lee's photographs that he took of
I'm sorry,
observations.
that wasn't one of the
It
items
was not
that were
included in the
briefed.
brief. Did you want me to put it in writing, Your Honor?
Yeah, why don't you put it in writing?
All right, thank you.
All right. Before we launch into this hearing, I received a response regarding Mr. Morrell's motion from the defense. Mr. Darden or Ms. Lewis, are you going to speak on behalf of the people on this matter?
I am going to speak on behalf of the people. We have not filed a written opposition. There is at least one case I plan on citing. I know the supplemental petition from the ACLU was untimely, having been filed yesterday. I will waive our objection on that basis if they'll waive the problem with the court taking it into submission until it has an opportunity to read the case I plan to cite to it.
Sounds fair enough.
Can we see the case in here?
Yes, it... It's a brand new and the latest advance sheet, Second District Court of Appeal case, People versus Feagin, F-E-A-G-I-N, at 34 Calat 4th, 1427.
What volume of the advance sheets is in?
I don't remember the number, Your Honor. It's, I just got it within the last few days.
May I ask to borrow that?
Sure.
I'm aware of the case, Your Honor.
All right, Mr. Morrell. Good afternoon.
Good afternoon, Your Honor. Thank you very much. First, let me introduce myself. Douglas Morrell, M-I-R-E-L-L, volunteer counsel representing the ACLU Foundation of Southern California. Joining me here in court is an individual who assisted me in the briefing on this, David Crochetier, C-R-O-C-H-E-T-I-E-R-E. Also, as the court knows, Ms. Sager is present as well, and she filed, as the court indicated, a joinder on behalf of 9 media entities, including all of the major television networks, the Los Angeles Times, and others. Since the court is aware of defendant's joinder, let me just simply note that also present in the court today, and I received a joinder from him, although he arrived too late to submit it to Ms. Robertson, is Rex Reeves, who is appearing on behalf of dismissed juror Francine Florio Bunton, and Ms. Florio Bunton is here in court as well. I want to thank the court first for allowing us this opportunity to appear before you and for hearing this motion.
Well, Mr. Morrell, forgive me for interrupting
Sure.
you, but I have familiarized myself with the motions filed, and let me cut to one particular issue that I'm interested in.
Sure.
It is true that a number of the jurors who have been dismissed from this case have voluntarily made their identities known to the public through the news media and have acquiesced to interviews, and in fact have affirmatively gone out and sought to be interviewed. Some have sought to financially gain from this experience. Let's assume that perhaps the court's interest in protecting the privacy of those individuals has disappeared since those individuals have voluntarily decided to put themselves in the public eye. However, a number of the dismissed jurors have not so made themselves public figures, have declined to be interviewed, have in fact been traumatized by the excesses of the news media in hunting them, and those individuals maintain that posture to this date. Should I make a distinction between those two?
Well, Your Honor, I think there are issues that may be raised that unfortunately we are not in the best position or really any meaningful position to address, because it may well be the case that with respect to the dismissal of certain of those jurors, there may be, and we have acknowledged this in our briefing, there may well be instances where releasing certain portions of transcripts of dismissal hearings might well implicate personal privacy interests and might well constitute an unwarranted invasion of an individual's personal privacy rights in a particular case with respect to particular information. I, however, cannot accept, Your Honor, the notion that a blanket order which precludes the release of any portion of any of the transcripts concerning any of the hearings, concerning the dismissal of any of these jurors, is appropriate under the governing law. It's not narrowly tailored. There's no compelling interest that's being supported by that.
Let's not even get into that argument.
Okay. But
Do you agree that there are perhaps some instances of personal privacy that the court should continue to protect? Let's assume that I'm willing to disclose those transcripts that involve individuals who've decided that their privacy is not of interest to them.
yes, no, I understand that. Let me say this. I think that with respect, for example, to, let's take the 2 jurors whose names have not been publicly disclosed as of this point. With respect to those 2 jurors, I would not expect, for example, that the court would release portions of the transcripts concerning their dismissal which identify them by name, if there are any such portions. However, I do believe, Your Honor, that there is every reason, and no good reason not to, release those portions of the transcript which describe the reasons why these jurors have been dismissed, which describe the evidence that was before the court, which describe the court's rationale for dismissing these jurors. So, with respect to them, for instance, I would say that at this point in the trial, it probably is appropriate to retain their names in confidence. With respect to another category of jurors, Ms. Hampton and Ms. Cheri, who I think are the two who have elected not to speak to the press in any meaningful way, although Ms. Cheri, I believe, did give an Associated Press interview 1 or 2 days after she was dismissed. But in comparison, at least,